Okay, haters, it's time for another episode of I Hate Real Estate. I'm here with my co-conspirator, Mr. Kendall Grooms. How are you?
I'm good. How are you, Jamie?
Can you take me seriously in this hoodie?
No.
Okay, I'm only taking this. I'm cold, and in case anyone's wondering, our studio is frigid, but Mr. Grooms just got back from Florida, so this is my welcome home because here in Arkansas, it's freezing.
Yep. We walked 77.2 miles. I calculated it today.
That was good exercise.
Yeah.
You went to Disney, didn't you?
Uh-huh.
Was it amazing?
Yep.
Did your kids just love
And
it?
most of that was pushing a stroller.
That doesn't sound as fun as it did before you said that.
No, my calves are still sore right now.
Well, I participated in a CrossFit competition over the weekend, so I have the same problem.
Yeah.
I just did all my 77 miles in
about 30
4 hours.
4 hours, yeah.
So we're going to talk about how my body feels today, which is dead. There are some things related to probate that can come up in real estate and cause quite a few problems. Have you experienced that?
Oh, yeah. All the time.
So talk to me first about what does probate mean when you hear the word probate as a real estate agent and your mind doesn't go like, uh-oh, let's go ahead and talk about why it should.
The most common situation is that it's usually a family member calling, wanting to sell dad's piece of property who has passed away.
And we have to start with the fact that at this point, when you first get somebody and the real estate agent first gets involved as well, we don't know anything about the situation until the will comes up, right? I mean,
If
so
there
first
is
they
one,
have
yeah.
to have one, right?
No, you don't have to.
So what happens if somebody comes to you and they say, hey, my great aunt Mildred passed away and I need to sell her house. I'm reaching out to you because you're a real estate agent. The real estate agent response would be, do they have a will?
Well, if it's a great aunt, that is a lot more complicated because there's a larger analysis of who the heirs actually are. Arkansas has a thing called the Table of Consanguinity, is what it's called.
Here we go with squiggly line words. I'm excited.
But the table basically says, here's the people that are first in line, second in line, third in line. It feels like you're going down the royal, the royal
bloodline.
Yeah, the bloodline. It essentially is what it is, though. And so you go down the list, and then there's also another way there's that table, and then there's actually a separate squiggly line statute that says exactly how things are supposed to pass depending on who's living in that line. So you kind of use the chart to identify where you go in this other statute, and it tells you how things are to be divided. Because even if, for example, your children are still alive, who would be the first priority, if your surviving spouse is still alive, one gets a certain percentage, the children get another percentage. So going to great aunt would mean you would have to determine if great aunt had kids on her own, in which instance if great aunt had kids and she's your great aunt, you don't have a right to sell her property in all likelihood. Right. So you have to analyze that. It's easier if you say it's a parent. Right.
So, but the basic starting is we're going to have to find out if they had a will to begin with.
Yes.
And then who's all the living people that would be involved with the person that passed away in order to put the right person in charge of hiring the real estate agent, right?
Correct.
So in your will, let's say that you say, okay, when I die, I want all my property to go to my son, but then that son is like either incarcerated or he's passed away. What happens if there is nobody listed?
Then it's just as if your will didn't exist.
Then, well, where do you start then?
It's called intestate. If you don't have a will, you die intestate. That's where you use this chart that I'm talking about.
Okay.
Because your will, you can give it to anybody. It doesn't matter what the chart says.
Right.
But if you don't have a will, or the people that are named in your will are no longer living, then it would pass according to the chart.
So
but that brings up a whole different circumstance.
This is what I don't like about lawyers.
This is where it's tiered on top of each other in probate, though, because if the person who's given the property has passed away, technically, unless there's some provision in the will that says otherwise, that property would still pass to that person's estate. So that person would then have to open an estate since they had passed away. Depending on what the language of the will says, it could go either way. And then you look to see if that person had any kids or other heirs that could take the property.
Okay, so
that could even arise in more than one situation of who would get the property.
So let's talk about kind of like a situation we have where someone passed away and there's two people related to this person. Maybe weren't close with him, maybe didn't know him very well, but the point is they became executors of his estate because he passed away without instruction, right?
Yeah.
Okay.
Let's say there is instruction.
Okay. So instruction, and if there is an instruction and somebody becomes the executor, then it's not just a regular sale, right? It's not a situation where you can just go in, sell the property, and close it. And the reason we want to talk about it not being a regular sale is because there's a whole nother set of things that have to happen in a probate case. So let's start with the beginning. I bring you my person's will. They've passed away. I'm in charge of executing their estate. What does that mean?
So what happens is you open a case. It's not a lawsuit in this instance, but it's a petition that you file asking the court to admit the will to probate. because the will has to meet certain requirements, squiggly line requirements. They have to meet that. And it has to be things like it has to be witnessed by 2 disinterested persons.
People who are not involved with the family and not involved with the property.
Yep.
That say we agree they're allowed to handle this.
It has to say certain things like it's the last will and testament. It has to be signed by the person. You have to have either testimony or another separate signed document that said they understood what they were doing. There was no influence being put on them to force them to execute the will. It
can't be last minute at the hospital bed.
And you have to be older than 18 years old, that kind of thing. It can be last minute in a hospital bed as long as you're lucid and you know what's going on. Yes.
Right. So you can make the decision. So, correct. But probate itself.
So once you get that process in order where you've said, court, we've met all of these requirements. Here's a copy of the will for the court to review. And they enter an order saying, yes, we're going to probate the will. And here's the persons who are going to be named as the executors. Those people will either be named in the will. It's called nominated by the will for the court to appoint, or if those people are not willing or no longer alive, the court will appoint whoever petitions. Whoever filed the petition will ask to be appointed as the executor in this case.
So probate for me sounds like, and this is just, very novice on the side of real estate. It doesn't matter how much appraisal and broker experience I have. This is law stuff. So going into probate for me sounds like escrow. It sounds like a period of time. Is there a period of time that the property or the probate has to be open before a property can be sold out of it?
No.
Okay.
You have to have an executor. You have to have somebody who has a court authority to do something.
So there's at least going to be the timeline involved of getting back and forth.
We refer to probate as a mother may I process. If you want to do anything, you're doing something with somebody else's property. So if you want to do, even as the executor, you're acting as an independent person. If you are named the executor, but you're also the person who's entitled to receive the property, that's 2 separate people according to the law.
Sounds like dual agency to me.
So you as the executor are the estate, and you as an heir are another person. So it comes up all the time when there's conflicts between you as the executor wanting to make a decision that's to your benefit as an heir, but that's to the detriment of another heir. And then other lawyers have to get involved because you're supposed to do what's in the best interest of the estate and all of the heirs, not just yourself, even though you're an heir.
So a good example of this would be, he owned 3 houses, one of which sat on the lake and is worth the most money. But like me, as the person who's the heir, I would like to keep that house and sell the other 2 that are not as profitable. But the person who lives in this house right now might not want me to sell their house because that's where they're living.
Right. It's a situation where if there were multiple pieces of property or other items to be sold.
Oh, there are always multiple pieces of property in a probate case.
Well, and you decide, though, that you want to sell this property over here that was supposed to be your sibling's property, but you want to keep yours. That's the kind of decisions that
they have to bring in their own attorney.
It can be in conflict, yes.
So if you say best interest of the estate, is this a lot like with my representation of a seller, my job is to try to yield the most profitable result for them if that's their goal. It's the same thing for the estate.
Yep, but it's still multiple different results here again.
Are there?
Because if the property doesn't necessarily have to be sold. Let's say the will just gives you the house. Okay?
Depends on the house.
The property doesn't have to be sold. Right. But the will is also going to have a provision that says all of my funeral expenses, all of the costs of my last illness if I'm in the hospital, any of that kind of stuff, any of my debts that I had,
children that
any
are
of my
still
debts
alive.
that I had are going to have to be paid if that are outstanding. Any claims that are filed against the estate that are valid and approved by the court, such as credit card debt, that kind of thing, are going to have to be paid. So there's a situation where, let's say the house is the only asset of the estate and you inherit it. You can't. Because if the person owes $50,000 and the house is worth $100,000 and the house is the only asset, that $50,000 has to be paid before any assets are going to be able to pass through to the heirs. So unless the heirs come out of pocket $50,000 to pay that stuff off in order to keep the house, they have to sell the house and use the proceeds to pay off the $50,000, and then whatever the cash is that's left gets distributed under the will.
So this is another instance too, where as a real estate agent, if you're presented with this, you're going to have to do a title search on this thing right away. I'm assuming because you're going to need all the payoffs. Like let's say that you think you got the mortgage paid off, but then you find out there's a second or perhaps a mechanic's lien, something on the house where you go to clear the title and you can't.
But even a credit card debt, even a debt not associated with the house whatsoever.
How would that even get bought into the probate unless you notify them of the passing?
You notify them and you file a publication in the newspaper that you publish it for, I think it's 4 consecutive weeks. It's either 2 or 4. I get the
claims.
probate and the quiet title publication time frame confused, but I think you have to publish it 2 times, and then there's a 6-month waiting period for claims to be filed after the publications are completed. And this
is not a profitable venture for a real estate agent, is what you're saying.
There's a statute. There's also a statute that says that any known creditors have to be notified. So as an executor, you're going to be responsible for going into this person's place of residence, house, apartment, whatever it may be, and go through their mail.
Yeah.
And say, hey, here's a credit card bill that came through. I've got to get the attorney to send a notice to this credit card company that this person's died, and if you have any money owed, you have to file a claim against the estate.
This is like my worst nightmare too, of somebody just like going through, even if it's not bad, even if I only have like subscriptions to that magazine, Zanimals magazine or whatever that comes in the mail every month for my kids. Like, I don't want you to know what I'm buying with my subscription box payments. Like,
well, a real estate agent, in all truthfulness, a real estate agent should never have to deal with all of this that we're talking about and explaining. It's important to know the process and understand that it's not always a quick process, but it's one of these things that the debts and stuff shouldn't be getting dealt with.
Well, but
maybe at closing.
Well, the mother may I process, though, is kind of where I feel like we need to concentrate, in the sense that, like, as a real estate agent, I never really even thought about probate until I started getting referrals from this attorney that I work with, and started to really dig into figuring out why I can't make certain moves. Because the probate court has all these different guidelines and timelines. They also have to approve the appraisal, right? Don't they have to look at all the different things associated with the property, like you said, and get the best interest? So if they get 3 offers on the estate and you're the agent dealing with it, and you present 3 offers to the probate court, you have to wait for the probate court to review and accept one of those offers, right? I mean, do they have any sort of say in which offer you accept?
That, again, that can go multiple ways. It depends on the court.
Let's pretend like my jerk family members are not there.
Some courts will want to see, here are the offers that we've got. We are filing a petition for the court to tell us which one to accept. Some courts are like that. Some courts will say, you got an appraisal done on the property. If you get any offer above the appraisal value as the gross value of the purchase price, you can take the deal.
Do you have to have an appraisal in a probate case?
The statute says that you do if you intend to sell the property. That's another area where it depends on the judge, though. I can't tell you how many times I've sold real property out of a probate without an appraisal. It happens all the time.
See why it's not fair that you get to do that with you get to do that with your law license and not your real estate license. Yeah. Lucky.
For me, the most important thing for a real estate agent to know is this mother may I process, that you have to get court approval. And what that means is that any acceptable offer is subject to court approval. So, I mean, every single time that there's a probate case, your client's going to be the seller.
Yep.
Okay. You're not going to be the buyer. You shouldn't be the buyer.
No, you might represent the buyer of a property that's in probate.
Yes. But you don't care about all the contingencies of the probate
until they delay your closing.
Your client does, because you're going to have to get some clearance from the probate court. But if you're representing the person who's trying to sell the property, if you're the listing agent on this thing and you get an offer, if it doesn't have the language in it of that this is contingent upon probate court approval, you have to counter. You can counter the identical terms back that are acceptable, but it has to counter that this is contingent on probate court approval in this case number. Probate case number.
Let me make a note to do this when we get off the air, because I am missing that document from this file. Live time missing this document on the file. But that's why it's important that we cover these kind of issues.
It can just be on a general addendum. I mean, you can send, not a general addendum, but the counter offer form. You can just send it back on the counter offer form. It says, offer, we're amending the other contingency section of the contract to say this is contingent on probate court approval. That's all it has to say.
But it's important to know this, because that's the thing is, first of all, I'm finding it out right now. But secondly, it's something that you don't deal with very often. And so it's another one of those situations in real estate. Let's say that you find out that this house is in probate after you've made the offer, after the listing agent has listed the property, and they have not taken the proper steps to make sure that this thing has entered. Okay, let's just scenario.
Yeah.
My brother passes away and he leaves his property to be sold. I'm a brand new real estate agent. I have no experience. I don't know a real estate attorney that I happen to be friends with or host a podcast with. And so I have to just go at it blind. If I go list this property for sale like I do in every other situation, because I know in my mind that he wanted me to do that and he said that in his will, but I just go forward and I list the property and I start working on it. We get under contract. I've got a buyer. We're moving to closing. And then we find out, wait. The will did say that you were going to be the executor, but I also had a sister and she had 2 kids and I wanted the house to go there. And then you find this out and you're in escrow. how do you back out from there? What can you do? Will the court just come in and stop it?
Yep. That's where you have to go tell the court, Judge, we need relief from this contract.
What if you close and then the sister finds out? Recourse?
There's probably recourse within the probate court. I've not had that situation come up, but I imagine there's recourse of some kind within the probate court system for some kind of monetary damage judgment for the value, that person's interest in the value of the home.
This episode is brought to you by Campbell & Grooms Law Firm. This small law firm has the tenacity to go after the big guy when your HGTV situation doesn't turn out so great. Remember, we started this show for a reason, and these guys know what to do when things turn upside down. Donald Campbell and Kendall Grooms are the Arkansas Trial Lawyers Association Trial Lawyers of the Year for 2019, 20, and I'm pretty sure 21's in the bag. Well, I'm going to throw that out to our listeners as far as if you've had a situation where somebody has closed on a probate case and you didn't find out till after and everything kind of had to be undone or redone, please feel free to send it in.
That's not something,
I want to know.
That's not something that's out there that would be uncommon for it to occur, because there are situations where, I mean, I work on cases all the time where there's heirs in a probate that have no idea who each other are.
Exactly.
They have no idea you're a family member. And so, but when you're talking about siblings like that, unless you have some like child out of wedlock thing or an affair that resulted in a child that you don't know about, which it happens. But if you're talking about siblings, it wouldn't be very common for siblings not to know. It's when you get in these situations of you had your great aunt who didn't have any children and whose parents were dead, that all of a sudden there's 17 cousins that are out there that you don't know about.
Listen here, though.
You could miss somebody in that instance.
I just testified in a case the other day for a friend of ours who's also an attorney, and I'm doing expert testimony on the stand, and I'm really just there for the value piece of it. But the reason why is because homeboy bought the property from somebody who signed the contract who literally had the same exact name as 3 other people in his family. So he made this deal knowing he wasn't the right one, but there were 3 others by the same name. Apparently, an heir by another name is not the same as the original heir.
That would be a situation where you would move to set aside the sale and undo it.
They finally did I guess they did a quiet title or something along those lines. But the point was, for me, is I couldn't believe that it had gotten through so many members of the family and nobody even knew who this guy was, although 8 of them or 9 of them had the same name. So it kind of blew my mind, where if you don't have a clear chain of title, of ownership, and of where it's supposed to go when the person who owns it passes away, it can create a really big mess, especially if you're halfway to closing when you figure this out.
Yep.
So is title search kind of your only way to really find out what is owed on the property, and how deep does that go? We should probably call Andrew on that.
Yeah.
Get a standard.
You do a title search, yeah.
Yeah, but when you do the title search, how can you guarantee that all of the creditors would show up? Because they wouldn't if they're unsecured.
Nope, you don't.
So you just check your mail and put that notice
out. But that's where that 6-month waiting period comes in.
You have to wait.
You have to wait once you wait the 6 months and you've published your notice, any claims that are not filed are barred forever. Period. And so if you owe $50,000 to a credit card company,
what they're saying is change your number and your address 6 months before you die.
Yeah, exactly. If your relative that passed away owed $50,000 in credit card debt to Discover, for example, and Discover does not file a claim, that $50,000 is barred, period. There is no recovery of that money.
I'm not going to say what my brain is doing right now.
So you can sell a property, a house, in the midst of this period of time, but the cash that you receive from it cannot be distributed to any heirs until that claims period runs.
It stays in the estate, doesn't it?
Yes.
In an account. And that's actually kind of similar to what we've got going on right now, because we've got one in probate that is getting ready to close, and it's got some bills on it from some repairs that were made, but those can't be paid until all of it the dust has settled. And then the estate will pay the outstanding bill, right?
Unless an insurance company is involved, then yes.
Yeah, well, this insurance company in particular is not paying this bill in particular, so we'll be waiting on the estate. Yeah. What would you say is the messiest thing as far as these go, a probate case goes? Because for me, I truly have been in a situation where I've never had to deal with it, except for being the listing agent of a property that has properly gone through probate, thanks to you. So what happened? What's the messiest scenario here?
The messiest scenario is when you get a situation where you've had relative after relative that should have been an owner of a piece of property, had a probate been done, not do probates for multiple generations. And so you get a situation, it multiplies faster than you can ever imagine. You have one person down here that owned a property who's even like a great-great-grandmother. and all of a sudden great-great-grandmother dies, nobody probates the property. The family members just say, well, we were her children.
I lived here. Yep.
And let's say great-great-grandmother had 7 kids, which is not uncommon. You get that. And the 7 kids, 5 of them don't even live in Arkansas. The other 2 stay and take care of the property.
This is a secret way of me finding out how my parents' property is coming out.
Let's say it's a farmable piece of property. They continue to farm the property, take the money because they're working it. Well, then slowly over time, the 7 siblings all pass away. They had kids. All of a sudden, the 7 has turned into, let's say, 21. Each of them had 3 kids. Well, now you got 21 kids, and let's say only 2 of those are even managing and doing anything with the property. Well, now you've got people living out of state that have no idea that this great-great-grandmother ever even owned this piece of property.
Or that they were entitled to a piece of it.
Exactly. And so you get to 2021, and somebody calls you and says, hey, my great-great-grandmother owned this piece of property. We'd like to sell it now and split the money amongst however many of us there are. We want to sell it. It's an absolute nightmare. It is a nightmare. We started to do one. It ended up falling apart because it's a nightmare, and the clients were like, forget it, we don't want to do it. And it had over 70 heirs in it. And I mean, you have to locate every single one of these
people. That's a huge family.
Then when you start dividing it out, one person that lives in Florida that has no idea who great-great-grandmother even was, all of a sudden they're entitled to 1/365th of this piece of property. Well, if it sells for $50,000, they're getting like $75 out of it. And they have absolutely no interest of any kind whatsoever in coming back and getting $75
or signing any of it or getting involved.
You got to get all those people to sign a deed potentially.
Well, and it's interesting too because when you talk about these outside creditors and the mix-up that can happen, I'm sort of like suddenly flashing back to like I have dealt with probate actually in my own life because when my dad passed away, it was one of those things where like he had kids, my mom has kids, and then they got married, and so the kids were everybody was kind of mixed together. There was no like but when he passed away, I'm sure all of his kids were probably like, where's the money? But it was like what you said. He had so many medical bills and was in the hospital that his estate went to start paying all that stuff out before anything. I mean, before mortgages, before we could sell the house, anything. That was the very first thing. So does the probate court, and I guess I'm just trying to mentally make sure I get this straight, does the death notice somehow get somewhere without a real estate agent or an attorney being involved to where creditors figure out how to come after this, or they just start sending the bills and the collection notices and then someone responds?
So a lot of these creditors, there's a company out there, there's probably multiple companies out there who search through publicly filed records, these death indexes. And the death index will be associated with a social security number. And they will have this company will go through and match social security numbers to death to debt. And so they will eventually
find out. This was a morbid person who created this company, but
this is something where the credit card company, whoever maybe, will eventually find out that this person has passed away.
But it's going to take some time.
And then if no probate's ever opened, they'll file what's called a demand for notice of proceedings, where you can't open a probate or get any kind of executor appointed or an administrator appointed without giving them notice of it.
Okay, well, here's a left field then. What if I'm driving by a piece of property and I see that it's totally vacant and it's got a disheveled property on it, and it's in really bad shape and nobody appears to own it? So I start calling and I start doing the research and I find out that the owner has passed away. It was paid in full. They don't have any living heirs, and I want to purchase that property. What happens in that situation? Does the county or state come in and foreclose and own the property? It was paid off.
Nope.
So what happened?
I mean, the only way you could become the owner is if the property taxes were being neglected. You could potentially buy it at a property tax sale.
I know some people that do that.
Down the road. There's also, you have to be interested in some way to open a probate on behalf of someone. So
you can't just like, I want to open a probate because this guy died and I want the piece of property.
If you found out there was some debt associated with the property, like let's say I don't know if the city would do this, but let's say the city had a cleanup lien on the property. The city will
put a cleanup lien on
where they
property.
Came and mowed the yard 5 times or something like that. Then if you could get the city to assign you the cleanup lien and you paid it or paid partial for the lien, then you could foreclose on it yourself and buy it through the lien. There's processes like that you could go through, but you're going back to the point of, if you want to buy the property, you've got to do a title search. You've probably got to do a person search to find out like a background search to find out who the people are that were the heirs. that are potentially entitled. But if you do enough searching, you'll find somebody.
So how to avoid this on the front end really is going to be to get your affairs in order, obviously, have your estate put together. So
there's ways to avoid this completely.
Yeah, I was about to say, so talk to me about the ways we avoid it, because my biggest concern with real estate agents is, and I've kind of mentioned this, but I'll go back to it in the sense that agents and brokers and appraisers, like if they don't have the full story about a property and they're just executing on the belief that they can sell a property for a certain price in a certain amount of time, they're going to execute on that belief, and they're not going to be aware that they can be stopped by all of these different things on the back end. And so I think it's important, especially visiting with elderly and or sick clients. I mean, if you're in a situation where you think they might pass away, you need to figure out what's going on. I mean, and I have a client right now that might not be 100% lucid a lot of times, so we have to have somebody else there to sign off on what she says, because what if she says she didn't say that or she doesn't remember it? And so talk to me a little bit about when you're dealing with a client who might have a situation like this, how do you best prepare?
Well, if the client's already having issues with being lucid, it makes it a lot more difficult. But before that occurs, there's a lot of ways to prepare for it. And I like to utilize what's called the small estate. And Arkansas has a deal where you can just file an affidavit of small estate if the value of the probate, like the estate as a whole, is less than $100,000.
Okay, that's hard to do. You're talking about real property, personal property, everything existing on the property being within $100,000.
Yes, but it doesn't include your residence. So your residence,
without the house.
If you have a homestead right to your house, it's not included.
So like my house
in the 100,000.
Right. So my house, if you're talking about 100,000, would be everything except for my house. So I'd really have to have $100,000 worth
in
of stuff.
Other assets, yes.
Right. And that's stuff without a lien. So like talking about a paid off car, right? Or does it have to be, what if it's a financed vehicle?
It's the net of the property.
Okay, because it's going to get paid out.
Yes.
So
when you do the form, you'll list the value of the property, the encumbrance on the property, and the net value of the property.
Okay.
And so if it's less than if your total assets are less than $100,000 in value, then you can file a small estate.
Okay. You're going to need to follow one of those for me.
Yes. Okay. And if you have real property that's a part of it, there's one publication requirement. It's similar to the 6-month requirement that you have in a regular probate, but you only have to wait 90 days. After 90 days, the property can be distributed. Okay. There's not even a need to sell it in that instance. You just distribute the property.
Especially because the real property wasn't
included. If the
included.
living heirs want to sell it, they can sell it in a normal transaction. No probate court involved, no probate approval involved, none of that stuff. They just sign on behalf of themselves.
Okay, but then I have a kid and a husband, right? So I have a husband and I have a kid who really is at that age where he thinks he can make decisions, teenagers. And I want to, let's say I want to create this small estate and I want to make sure it's in place before I pass away or lose my mind so that they have the ability to go through what I wanted them to do. What if my husband or child doesn't agree with how I wrote it in my will and I'm gone?
Well, the small estate is not something that you write in your will. That's just that's a determination of
just
whether you can
ownership.
file it or not. There is no preparation for, like in a will, of saying, I want you to do this as a small estate. That's not the way it works. You have to analyze what the assets are at the time of death to determine whether you qualify for a small estate.
Okay, so first I die, and then we look at the estate and see which do I qualify. Do I qualify for a small estate?
One method. It's literally of the day you die. You did no other estate planning other than you did a last will and testament. If you do a last will, then we assess afterwards, can this be a small estate? If so, then you can file a small estate. You can probate the will as part of that small estate. It's do the publication for 90 days, open, shut, done. You're finished with the whole process within 95 to 100 days, within 3.5 months.
Talking to a real estate, that's like forever. That's like...
Well, a full probate takes at least a year.
Yeah.
And most times 18 months. So
you
you're
really
cutting
have
the
to
time down at least 75%.
But it goes back to this is not a situation where you can move quickly.
No.
You're going to have to mother may I every single step of it, regardless if it's a small
Correct.
estate or big estate. And your shortest time sounds like is 90 days.
But that's from start of probate to the date
Close.
of sale. If it's a situation where I've already opened a probate and I'm just bringing a piece of property to you to help me sell, to list it for clients, it's a pretty normal process at that point, because usually I already have the order in place allowing the sale to occur.
That's
one that we had, though, there were a few more steps we had to take, but usually it's organized and it's ready to sell at that point in the normal course of a real estate transaction. But if someone comes to you with a house of, this was my dad's, he's passed away, we want to sell it, yes, it's at least a 3.5 month process to get it sold. In all likelihood, if they don't qualify for the small estate, it could be a year or more.
So what is the best opportunity for someone who has a small estate kind of situation? And we'll talk about what's bigger than that afterwards. But if you have a small estate kind of situation, what's the very best thing that they can do to prepare their loved ones and or the person that is, I like how I'm going to separate them, their loved ones or the executor of their estate. How do you best prepare yourself to be able to, and could you name a real estate agent and broker? Could you say like, hey, look, if I pass away, these are all my assets. I would like my fiduciary that's helped me with my other real estate stuff to handle all this. And I want to sell off all my property for market value.
Yeah.
Can just name them in advance.
Yeah, but the selling at market value can't be done without court approval, even if it says it in the will.
Which brings it back to the appraisal.
Yeah. The other scenario is you can make it where this is how I set it up. You can make it where
it's going to be complicated.
You can make it where you never have more than $100,000 in personal assets
because you keep on breaking everything down.
You set up a trust.
Yeah.
It's as simple as that. You set up a trust. We tell people that setting up a trust is like having another family member. It's like you had another kid. They own things separately from you. The trust does.
It's like an LLC without all the obligations.
That's right. It's like right now, this very moment, I own nothing but my vehicle. That's it. I own personally nothing else.
That's smart.
I think I may have a bank account or something like that that's joint with me and wife. But that's it. And so...
Like I said, me and wife. Shout out, Carrie.
Yeah.
I was like, sorry, everybody knows you're married too.
I'm saying that's the way you can set it up, and you can set it up as such with a trust where as long as you manage the trust properly and you don't like win the lottery and don't move any of it into the trust, into the assets of the trust.
Then if you die, then everything is separated out.
That's right. And so what you do is your will gives everything that you own to the trust, and then the trust acts as the will. Then there's no probate. Then you just wait and you do the small estate where...
Then you're 90 days in and out.
You're 90 days done, and the trust handles everything else. Even if I have $10 million of real estate assets in that trust, that's it. Then the trustee of that trust can start selling things in the normal course of business.
So really, you could set this up to be like, here's all my real estate stuff. Here's the trustee over this trust.
Yep.
And here's all my personal stuff. And here's the trustee over this trust.
If that's how you want to do it, that's more complicated than what I even usually do.
It doesn't sound as complicated as not doing anything.
You have to have an understanding of how the system works, though, of what counts towards the $100,000. That's a conversation that we have with clients all the time about here's what you have to do to make sure you don't go over that $100,000 threshold, because if you do, it destroys the whole planning.
And then the plan falls apart, so you can't go into like a new plan. It's all of a sudden just...
Essentially, if something is owned by a husband and wife jointly, it automatically passes to the other. And then the second to die is the one that has to have the correct setup done. If you have anything out there like a life insurance policy where you can designate a beneficiary, any money that passes to a designated beneficiary doesn't count towards the $100,000. A bank account, everybody knows what a payable on death is, a POD account. Mm-hmm. If you have a bank account that's in my, like if Kendall Grooms has a payable on death account that has $1 million in it, which I don't have, but if I have one,
I wasn't planning that,
and I named Jamie as the payable on death person, that $1 million does not count towards the $100,000. Period.
Because it's life insurance.
It passes outside of probate. And so what you do is you set it up where the trust is the payable on death, or is the beneficiary of the life insurance policy, or the beneficiary of the retirement policy. Anything that passes in that manner where you can have a designated person to receive it directly from a third party, that doesn't count towards the $100,000 either.
This is
so
like
it's all
taxes.
about
There's all these different rules.
Setup. It's all about setting it up correctly, and if you set it up correctly and understand how to manage it, it makes it a lot easier.
Yeah, this reminds me a lot of the conversations that Angela and I have about how to set up different taxes and LLCs and different things like that, because the planning portion of it is so important that the execution almost becomes...
Well, setting up the estate planning, if you just come into my office and you say, I want to do a will, it's a whole lot cheaper than it is to set up all the trust stuff that we're talking about now. But in the long run, when you actually go to a probate, the probate will cost you 5 to 10 times more money than setting up the trust will. And you don't have the headache of waiting a year, 18 months, whatever it may be.
Well, and in markets like this, I mean, right now it's working in the favor of a seller, but there is going to be a time where you're in a situation where it is a buyer's market, not a seller's market, and the value of property will change rapidly enough to affect your probate.
We've been there recently.
We are currently there. That is something that I think is really important to keep in mind as well, because a lot of real estate agents and brokers don't experience probate on their everyday, in their everyday work. They just don't come across it very often. For me, I've only dealt with, I think, 4 probate cases in my whole entire career, and I've been in it like 17 years. So it's, you've probably dealt with more because that's your job, but it's one of those things where you're dealing with the emotions of it. And I think that that's the important part to remember as a real estate agent is you go in, you're dealing with somebody who has just lost a family member and or has passed away, and somebody's handling their property. So you're already emotionally invested in this client and trying to make sure that they have an easy time. So your lack of understanding about the situation and how it has to go can very negatively and adversely affect the situation because you aren't well versed in what does a probate mean? What do I expect from the court? I would say that in my personal opinion, without selling your services, too cheaply in the sense that I'm like, everyone just call Kendall and ask questions. But for real, talk to me about what you would do if you were a real estate agent or broker and you came into contact with a client that may have a situation impending, like you did with one of my friends where you had to handle his power of attorney and all of those kind of things. You know that the death is coming. You know that there's a lot of things you're going to have to deal with. Walk me through those steps.
Well, the real estate agent only has one choice. I mean, they can't give legal advice. Even listening to this podcast and
I'm not giving any legal advice.
And
disclaimer.
giving the same advice back out would be considered to be legal advice. So, I mean, you have to refer them to an attorney, whoever it may be.
I just referred to you.
Anywhere. I know, but it doesn't have to be. There's plenty of people out there that do probate work.
Yeah. But what I'm saying is that, like, as an agent, that's your first piece of advice, right?
It's the only piece of advice. You can say, this is going to be in a probate. It can get a little complicated. We can get it done, but you've got to have an attorney involved.
And everything that I do is going to be under that probate, the guise of that probate.
There are people that go do small estates on their own all the time. All the time. People go do it. I've cleaned them up 24 different times in the last 2 years of people that go do their own and think they can do it, because you can walk into the clerk's office and say, can I have a form affidavit of small estate? And they'll put 2 pieces of paper in front of you and you fill out the information and sign it. And I've seen people that only put their name as the heir and not their family members, whether not even intentionally.
This sounds like taking an Office Depot contract to a title company.
It is, but the problem is that if they're trying to sell a house, none of them, the clerk will not give you advice. They don't know about the 90-day publication requirement. And it's caused all kinds of problems with mortgage companies, because you may have a property that had a mortgage and the mortgage never got paid. They're trying to find out what's going on. Title's been transferred by someone else who filed an affidavit of small estate and then went and filed a deed. And it gets really messy at that point.
It sounds like a lot of undoing, and that would be my biggest concern.
If you have a real property involved, it's always more complicated than it is with personal property. If I'm dealing with a personal property only probate, it's very straightforward and usually simple.
Yeah,
when you involve real property is when it becomes a little more complicated.
Well, and that's the difference between, you should already know this from real estate school, but the difference between the real property and personal property is the real property is the actual property affixed to the physical piece of land. So this is not the curtains.
The personal property is bank accounts and
cars
vehicles, and furniture and boats and things like that.
Yeah, ladders,
coin collections. We get coin collections.
Well, and
we
it's
had a lady
because
one time that had a signed photo of the Beatles. I mean, it's just that kind of stuff comes in.
This is the funny thing about the probate too, is you actually see the list of every single item that's in the house and what it's valued at. And so you have to have an appraiser, not the kind that I do, but like a personal property appraiser will come in.
In some instances,
you can actually get, like, I wanted to start a network of these people like I did with experts, because you get appraisers that work on jewelry, appraisers that work on cars, auto mechanic. I mean,
there's certain things like that, those things you just listed, where you get a specific list if they're valuable. But a lot of times things like furniture, other personal property, we'll just say miscellaneous personal property and lump a number into it.
Canoe.
I have had a client one time who decided that she was going to itemize everything, including like forks and knives, and individually price them, and gave me like a 75-page list of property.
Those of
we
you
just
who are
attached
preppers,
it and said, here it is.
Yeah, those of you who are preppers, those kind of people, go ahead and get your Excel spreadsheet out and start itemizing the things you want people to know you have and what their value are, because Kindle's not going to do that for you.
I can't.
Well, okay. So as an agent, as a broker, the most important lesson that you can take from this episode is understanding that probate is an actual process. It's like a mother may I process that's going to be at a minimum 90 days and at a average probably about a year. And then looking over probably in the more complicated, like 18 months to 2 years, right?
I would say even if a small estate gets filed, by the time you actually have the right to sell the property, it's probably closer to 4, maybe 5 months. Because there is a little beginning waiting period when things get organized, because you can't actually file the affidavit until 45 days after death. That's the first time you can file it.
Well, and this is something that I really think is super, super, super important from a professional standpoint as an agent or broker. Yes, you cannot give out any legal advice. However, as a fiduciary for a person who's going through a very difficult time in their life, who's about to have to unload property that may or may not have belonged to them, they either may or may not have knowledge or understanding about how the process goes, and they're obviously in an emotionally kind of frustrated situation because they've just had a major loss. Your job as the agent and the broker is to be professional enough to refer them to an attorney, because that's the attorney's job, and then to be patient through the process and follow the mother may I all the way through the probate.
I can't tell you how many probate cases that I've done with real property involved. I don't know that number. But as far as it being emotional, usually by the time somebody comes to us to start selling property, it's set in at that point. I can't think of a single instance where I've had somebody in my office that's like totally broken down selling mom or dad's house or something like that.
Well, and you probably get them to an agent so quickly as well that they're dealing with the property piece of it, and you're not really.
Yeah, I mean, usually within a month.
See, you say a month though, and real estate agents are going, oh, that's a whole escrow period. I mean, that's the thing, is you're used to waiting. And what I think is important to take away from this, not only the steps to understand how to handle it, but then as an agent to understand the patience involved with this. Yeah. I mean, we started talking about the case that we're closing, I believe it's tomorrow, but it may push to Friday. The point is,
it's not fast.
We started working on it like 6 months ago, and it's not that complicated. I mean, you started working on it long before that, but for me, it's been like 6 months, and it's not even closed yet, and not a big deal. Nope. I'm not not complaining, but you have to be ready for the patience that it takes to get through these things.
You do.
So, anything else you want to talk about with probate before we let our listeners go today?
I don't think so. I enjoy the process of probate. It's something that it's actually structured.
Yeah.
It's not something.
It reminds me of bankruptcy.
We've talked about all the different options and things and how it may flow, but when you come in with a specific set of facts and what happened, it's real easy to line out, okay, this probate fits into this, and this as far as categories, and we will go from there. There's not questions like if I get in a piece of litigation where you're looking at new evidence, you're looking for evidence, you're looking for documents, communications, things change as you flow through it. The direction that you go changes. It doesn't. A probate is set. Once it starts, you can figure it out pretty quickly about where it's going to go. The only thing that you may have is you may find an asset that you didn't know about. I mean, that's happened from time to time. Or a person. But even a person doesn't change anything. It just changes the numbers.
Yeah. But it's interesting because there's so many situations in my life that I could think of right now, just with clients and people around me that I'm like, they don't have a will set up at all. And then something terrible could happen. And that, people don't wake up the day that they die like, I'm gonna go today. So there's never a plan.
Better call my lawyer this morning.
Better call my lawyer and set up a probate. And I think that, as morbid as it sounds, I'm trying to cover as much as I can on this show that's going to help agents and brokers. And it's something that I hadn't thought about up until I started working on this case more recently. And then I've got that other woman who's kind of struggling, and I've been thinking about her going, I wonder how this is all set up, because if you don't have that stuff in line, you can create a huge mess for Kendall to clean up or another attorney to clean up on the other side. So as a professional,
now, I will say, if it's your intention, if you walked into my office and your spouse had passed away, with the two most common situations that we get where we set up probate is where someone's spouse has passed away and they're wanting to make sure that it passes appropriately when they die, or when somebody has a kid. Those are the two most common times when probates get set up. But when you come in, if your intention as a widow, for example, is to give property to your two kids who are alive, you want it to go to them. Mm-hmm. There's no reason to set up a probate.
No, because it's going to pass immediately.
It's going to pass to them immediately anyways.
Unless I got remarried, and then I'd be in trouble.
The only reason what you would need to set up is this $100,000 threshold. If you own more than $100,000 in property that would be part of a probate case, not these life insurance policies and things we talked about, then you need to work on setting up a trust and some probate work. But otherwise, if you don't, if the entirety of all of your assets, if you're renting a house,
if you're 98% of America,
and you're on Social Security, and you've got a savings account with $50,000 in it, and you own a $10,000 vehicle, and there's no reason for you to set up a probate. It's going to pass anyways to those two kids, and that's called intestate. That's where you get an administrator appointed, and you can still do the same exact process. It just doesn't have a will involved.
Yeah. And I think most people have that simple setup. Most of them do. But then you have these people who have, like you talked about, big families, lots of assets, lots of real estate, lots of things that need to be decided on past their death, and they're not going to be there. So if you're a control freak, this is also a really good opportunity for you to flex on your
outside of the
skills.
Real estate market, outside of talking directly to real estate agents about how they need to handle it, it's important for individuals who have family members that have passed away to handle the probate. The longer you wait, the worse it gets, because even if you're a family of 3 siblings, if it's you and 2 others, if one of your siblings passes away and they've got 4 kids, it has instantly become more complicated. And you don't know when somebody's going to, like you just said, you don't wake up in the morning going, I'm going to die today. It doesn't happen. And
people
so,
never prepare for that because they think they're going to
No.
live forever. I mean, I know I wake up every day thinking today I'm going to do X, Y, Z, and I never think about what happens if today, is the last one. And I just think it's really interesting too, though, because in our line of work, we're very temporary. We're moving on to the next client, moving on to the next client. And sometimes when these morbid situations pop up where somebody dies or they need to deal with a probate, we can get really inconvenienced by that. But what we can learn as professionals is like, hey, let's take this lesson from it and advise our clients in advance to deal with the professionals they need, not just an attorney, but probably a tax accountant as well, to make sure that we have an understanding of where the money goes, where the property goes, and so that nobody's fighting, because I can't tell you like how many movies and shows have been written about family members and you know what I mean? It's like they probably don't publish as many instances as happen when families start fighting over what's left behind.
The money in a probate brings out the worst in people.
I was about to say, here we go. We don't have enough time for that episode, but one of these days we will throw down. We should have an episode where we do reenactments of what happens in your office when people find out.
Without going into detail, it's the same thing. I can't tell you how many times a group of family members have walked in and said, we're good with everything, everybody's agreeable, and it's not.
No, yeah.
About 30 minutes later, it's going downhill.
Yeah, well, I can tell you this right now. I think these are really important because I've seen families fight over stuff like at the end, and not even so much probate. For me, it's mostly been like my interest in the property. Well, I have an interest in the property and I want it to be worth X, Y, Z because I want my share, but there's 5 siblings. And so when we go to sell the property and we split it out, this guy wants a way higher price because he thinks he's going to make more. You know what I mean?
Yeah.
And when families get involved, you're all of a sudden dealing with all their family issues, and then you start bringing money into it.
Well, and I'm not stereotyping anybody or anything because I'm just talking from experience, but the worst ones as far as family members bickering and fighting about the probate process is when you have children and you have a parent that had already died and that parent remarried, then the biological parent dies and the remarried step parent is the one that's entitled to some of the probate. Those get ugly
But
sometimes.
see, that's the reason why I mentioned that, though. That's the reason why I mentioned that, because 2 things were running through my mind. Like, this is how my brain works, so I apologize. But my brain was going like, okay, well, what happens if the person gets remarried and then the person who died, like, they never went in and changed their life insurance, right? And so then the ex-wife gets the money, and the current wife's like, I've been married to him for 20 years. You guys got divorced 20 years ago.
It wouldn't happen under the insurance. Well, it would only happen if the ex-wife hadn't died yet, but that's happened as well. And there's Arkansas law on that says the ex-wife gets it.
I bet that was a dramatic case to watch. And that's the thing is, it might say the ex-wife gets it, but what if the new wife is named and the ex-wife just didn't know, and she's got all the kids, and then here comes the money to the new wife? That happens too.
I don't know the name of the case, but there's a keystone case in Arkansas where someone actually mailed off the document to change the beneficiary to the new wife, and it never actually got processed by the insurance company. But the Arkansas court said that act of the intention to change acted as the change in beneficiary, and they actually found that the person who was intended to be changed to the beneficiary is the person who got it.
Well, and that makes sense because he mailed off the letter.
But if you don't make any kind, if you don't make an active step or show an intent to change it, other than saying, hey, one day I'm going to get around to changing this, then it's whoever's on the documents who gets it.
Well, and here's the deal. Like, I hate it, and that's why it's on the show. I hate that people have to die and pass their property, and there's all these complexities that arise from it. But it's one of those things that agents we don't talk about it in real estate school very much. You'll talk about adverse possession, where somebody comes and lives on your property for 7 years and takes it over, but you won't talk about, okay, when somebody dies, how does this estate break down? What is the difference between an estate where they have a certain number of assets versus another, and how does all the property pass? So I think it's really important for people to stay abreast of that, and then also prepare for the worst. I mean, I know that people want to be positive. I want to be positive, but the way that my mom has always said it, and that I feel like as an attorney you probably believe, is that prepare for the worst, and then if the best happens, that's great. But you should get it all down on paper, all written to a way that you're happy with it, so that if you wake up or don't wake up tomorrow, you know where everything's going to go and how everything's going to fall.
And from a real estate agent standpoint, I want to reiterate it because I tell it every time. The most important thing is to get that contingency in there, that it's contingent upon probate court approval.
I'm doing that right now when we leave because I actually did not.
That is very important.
This is also a disclaimer to show that I am still learning all these years later to add verbiage to contracts, but not the kind that practices law.
If you don't have it and the executors sign it, technically they have bound the estate to sell the property, even if the court doesn't approve it. And then you're jumping through all kinds of hoops of undoing the contract. And there may be a statute out there that controls that if there's no court approval that it's void. I don't know. I've never had it happen because we've been
because you're great
in communication enough with our realtors to get that in place, even though it sounds like you didn't do it. I guarantee you I have
To
an
be
email.
fair, you were in
I guarantee
Florida.
you I have an email telling you to do it.
Yeah, well, you were in Florida while I was closing up this deal, so it's probably in your email, actually.
But if you are
I'm
a
just
listing
kidding.
agent, you have to counter, no matter what.
You know
Period.
why? I know why.
And say that it's contingent on probate court approval.
I know why. Because I handed it to a buyer's agent, remember? Because I didn't want to be the only other agent involved because I felt like dual agency and probate would be too.
Probably so.
Yeah, because I felt like that would be terrible to be trying to act on the best interest of the seller in a situation where he's representing a dead family member and then as an executor. And then I've got another agent where I'm like, I'm going to put you in between because a buyer called and wanted to buy the property through me. And I was like, no, I can't represent the estate and the property. There needs to be another agent. So I gave a referral. And I think also, when those situations arise, it's a good opportunity for you as an agent to teach someone else about a situation like this, because this other agent who's working on it with me, who has the buyer, has never been through probate. So they're in a situation where they're dealing with a bill of sale on all the personal property that exists. We went through the bill of sale process. We went through all this, and now we're going to have verbiage to add to both sides of the contract. Yep. But that is why, by the way, because I was doing the ethical thing.
There you go.
You're welcome. There are reasons he works with me, you know. So before we go, we're going to rule. Sorry that your gavel was late, but you can now approach the bench.
It has arrived.
I feel like what we need to rule on today, you can talk about the contract verbiage because I have no right to now.
Okay.
But I will go ahead and say that as a real estate agent and broker, you need to be well versed in probate, because although you cannot give advice about it, when your client goes to that process, you need to be able to know, A, where to direct them to get that all planned, B, how to comfort them when they're losing their mind about these deadlines, and then, did I say 3 or C? Three. Okay. And then 3, make sure that when you're dealing with this, you take a step back as an agent and understand your role here, and that you're not involved with any of the family members or any of the property. Your job is to execute on the contract that you've been asked to execute on.
Yep. And it may not be a quick process sometimes.
It will not be a quick process at all. We're looking at long closings at 45 days. So when you talk about 90, you're already like past my threshold.
Yeah. But even at that, though, a lot of times, and I will come back to your ruling, but a lot of times, again, I won't present it to an agent until it's ready, until there's an order. So this whole,
but
we're going to file.
You, Kendall. People
I'm just saying this whole, we're going to file the affidavit of small estate and wait this period. I've usually got that done at the point in time that somebody would be listing the property.
By the time you came to me, and this is a good example.
I just don't want to deter agents from turning down, that listen to the podcast, that now have an understanding of what they need to do, hearing the word probate or that owner is deceased, and just saying, no, I'm not going to do it for you.
No.
And then it puts these people into turmoil because they don't know what to do. They think there's not an agent that's going to help them.
Well, if anything, I would say that the opportunity for an agent is greater. Because for me, I get the opportunity to serve a family who really needs it. Whether it's a family or an individual, they don't know what to do. And as a professional, you go in there with your second language, which is real estate, and you execute on that without them having the confusion or the worry or the stress of how to properly market and sell this piece of property. But then additionally, it's like with a VA loan or FHA loan, you'll hear a lot of like, oh, they're difficult to work with. Like, no, those are some of the most well-qualified, hardworking buyers who need an extra layer of protection. And when they get financed through that process, through an FHA or VA, they do have stricter guidelines for a reason, because those are different kinds of insurable loans.
That's a great comparison. But that's what I'm trying to do. I don't want to scare people away, scare agents away from helping people and getting them to the right place.
I'm just trying to get all the business to me,
when
Kendall.
we're trying to, when we're trying to do the podcast to tell people, here's how to avoid these issues. Here's how you as an agent can avoid some of these problems. And here's how you can prepare your client, or as a consumer trying to buy a property that's in a probate, having an understanding of here's what may happen if you try to buy a property out of this probate case.
Yeah.
Or from someone that's passed away. It's not the end of the world. It's not something that's a horrible, miserable situation. It gets done. It just takes a little bit more time.
Yeah. And it makes you a better professional. You learn more. And it's one of those things, like just like I said, as many years as I've been in the industry, I just didn't have as much knowledge as I have about it now, but I enjoy those experiences because they make me, I have more depth and more width and more ability to handle things when I learn through this process. So I appreciate everything you've taught me about probate through this interesting case and the case before it.
Well, I'll rule that you need to be sure you put in your proper contingency.
Okay, and I'll rule
and
that...
you had 1, 2, and 3.
I have... Okay, well, 1, always take the probate client. It's not a problem. It's an opportunity. 2, always make sure that you use a good attorney. If you don't live in Arkansas and you can't use Kendall Grooms, use an attorney that you understands probate. And then lastly, what was the last one? I think it's you and your contract verbiage. Lastly, don't say anything that you don't know. Don't practice law. That's what it was.
Yeah.
Do not give unauthorized legal advice as a real estate agent.
That's it.
That's it. You're back from vacation. While you were gone, I've opted for the hoodies. We've become very casual.
Perfect. That's why I like it.
Next time I see you, I hope you look like a slice of pizza.
Yeah. Hopefully so. Halloween time.
All right. We'll see you guys on the next episode of I Hate Real Estate. Keep being hateful. We'll see you next time.
Bye.